Okay.
I think it's recording. You need to.
Good evening to Dr. Zahira and all my fellow friends. We are from Group 1, consists of my Chen, Abakar, Abdul Latif, Nasim, Pratus, and myself, Sarai Zulikma Putri. Next slide, please. For our group, we're going to talk about the case of Jaya Sutir RL Jayaram versus Nautical Supreme SDN Berhad and Ors in 2019 regarding the topic of anti-arbitration injunction. Next slide, please. First, we're going to talk about the background fact about the case. So this is regarding the Nautilus Tuk and Towik SDN Berhad, and hereinafter we're going to call it about the Nautilus. It was a joint venture company formed to undertake a project for the provision of harbor Tuk services. This shareholder were Azimut Marine. Hereinafter we're going to talk this name in Azimut, and Nautical Supreme SDN Berhad. Hereafter we're going to call it as Nautical Supreme. And the plaintiff was Jaya Sudir Jayaram. Hereinafter, we're going to call it as Jaya. He was not a shareholder of Nautilus, but claimed that he had agreed to invest in the project based on his collateral understanding with Nautical Supreme and Azimut. With these 3 points, the first one is Azimut would hold a part of its shares in Nautilus in trust for Jaya. The second one, Jaya would be entitled to participate in Nautilus equity. And the last one, Jaya contended that both shareholders had acknowledged his beneficial ownership to the shares and 10% of the share in Nautilus had. And I will pass to the next presenter, Nazim.
Thank you, Soraya. I will continue presenting the background facts. So, however, Nautical Supreme denied the existence of such collateral understanding and commenced arbitration proceedings against Azimuth and Nautilus. In accordance with the arbitration clause in the shareholders' agreement, Jaya was not a party to the shareholders' agreement, hence was not a party of the arbitration proceedings. Therefore, alongside the arbitration proceedings instituted by Nautical Supreme, Jaya commenced a claim in court against Nautical Supreme, also applied for an interim injunction to restrain Nautical Supreme, Azimuth and Nautilus from continuing with arbitration proceedings. Jai Sweet. So let's continue with the next presenter, Abu.
Okay, thank you, Nasim. So I'll proceed with the findings by the High Court. Jaya was a party to the shareholders agreement, hence could not seek the recourse through the arbitration proceedings. Jaya could only ventilate his claim through civil proceedings in court. The second one is the provisions and the Arbitration Act 2005 have no bearings on Jaya's suit, as Jaya was not a party to the arbitration proceedings. The third one is the applicable test in relation to the injunction application in Jaya's suit is the test set out in K.T. Garlard, Francis Noel John versus Muhammad Noor bin Abdullah, namely that there must be a serious issue to be tried. Damages will not be an adequate remedy, and the balance of convenience lies with the granting the injunction. So the fourth one is the test in the KT Gerlach was satisfied. Firstly, there were serious issues to be tried, as the existence of the collectoral undertaking could only be determined after a full trial. Secondly, the damage will not be an adequate remedy, as Nautilus share were not readily in the market. Thirdly, the balance of the convenience was in favor of Jaya's injunction proceeding over Nautical Supreme's arbitration. This is because the issue raised in the arbitration proceedings overlap with the issue in Jaya's suit. The fifth one is the advantage of having the court proceedings take priority. Priority is obvious. As all relevant parties are involved in the court proceedings and the contesting claims can be ventilated in the court proceedings. So next I will pass to Margin Chang.
All right, as Abu said here, like since the provision in the Arbitration Act 2005 have no bearing on Jaya's suit, as Jaza was not a party to the arbitration proceeding. So we know that the High Court has not gotten the relevant result with Jaya's proceeding. So I say the third reason it says about the balance of the convenience was in favor of Jaya's injunction. So proceeding over nautical superman's arbitration, and here in the cause of appeal it shows that the court should have due regard to the objectives of the Arbitration Act 2005 as a whole, up to uphold party autonomy and to limit judicial interference with the arbitration. So the Court of Appeal considered that the correct legal test for the third party to restrain arbitration proceedings should be as set out in the case called G. Jaya, Jarvis versus Sons on the versus Blue Circle, Dartford Estate. So with this cause, it says that ordinary delay is also a material fact and can be fatal to an application for an injunction. So in other words, it says like no party to arbitration would have to satisfy a higher held to merit an injunction to arbitration proceedings than that record of party to arbitration. So as we can see, the last case, it says like inordinate delay is also an material fact and can be fatal to the application for an injunction. So as here, the Jaya has been delayed for 10 months. And after that, he didn't find any reasonable explanation or evidence for the injunction injunction to the arbitration proceeding. So which means the court has no longer supported him without any evidence, and the Court of Appeal held the Jaya's application should fail. So this is the result from the Court of Appeal. And the next one I'm going to pass to Abdul Latif for Federal Court.
Yeah, thank you so much, Man. Thanks for all the presenters presented previously. For now, I'll be actually talking about the findings by the Federal Court. I'm gonna go through the points one by one quickly, and I'll try to simplify things. Let's start with the first point over here. The first point by the Federal Court is saying about, or it's describing the Arbitration Act 2005. And to be honest, this Arbitration Act cannot be applied to, let's say, a party that is not under the scope of legislation. So that means that Jaya will not be affected by the Arbitration Act. Secondly, you have the second point over here. And in this point, point number two, the Federal Court is somehow against the appeal court in terms of imposition, the non-party to the arbitration. And it's considered the arbitration as a flood. It's not acceptable for Jaya to interfere and to restrain the arbitration proceedings. Another thing here, in the last point of this slide, we can see here in number 3, the thing that the Federal Court is concentrating on is the consideration when we can grant injunction to restrain the arbitration proceedings, and why it is there. The essence of this, or the main consideration here, is the benefits. because it's stated clearly here that the benefits must outweigh the advantage. So when actually the benefits actually outweigh the advantage, then they will consider actually restraining the arbitration proceedings. Let's go to the next slide over here and understand the remaining 2 points. Point number 4 is talking about the delay of 10 months because Jaya was actually interfered in the arbitration and was delaying the arbitration actually proceedings. And for the federal court, it is not reasonable and it's not justified and not acceptable. And let's shift to the last point here, which is point number 5. The point number 5 over here, in terms of the federal court, it has actually a point of view where the dispute cannot be actually divided, like it cannot be dealt by court and arbitration. It's supposed to be dealt only with one side, either the court or the arbitration, but it is not possible to be dealt with or it cannot be actually dealt by the arbitration and at the same time with the courts. It cannot be divided and it is wrong to be divided. That's all from the federal courts. We're gonna shift to the next presenter.
So to conclude, the federal code. To conclude, there's 5 points. The first one is the federal code appeared to recognize the ability for parties to an arbitration to apply for an anti-arbitration injunction, i.e., a court granted injunction to restrain arbitration proceedings. This is despite the AA 2005 not having any provision that allows for this, and despite the application of Section 8 of the AA 2005. The second one is a non-party to an arbitration can apply for an anti-arbitration injunction to restrain the arbitration between the arbitration party. The third one is the court favored court proceedings, taking precedence over the arbitration between arbitration parties. Concurrent court and arbitration proceedings would also appear to be not allowed once there is the risk of inconsistent findings. The fourth one is this decision now brings the risk of tactical filling of court claims by non-parties against arbitration parties. And the last one is the position in Malaysian law is that it is now easier for a non-party to arbitration proceedings to obtain an anti-arbitration injunction than a party to arbitration proceedings would. That's all from us. Thank you so much.
Yes, thank you. Thank you very much.
Thank you very much, Doctor. Thank you, everyone.